The next case on our docket is King versus the state of Florida.
Good afternoon. My name is Gonzalo Index, and I represent Mr. King. This is a case where a 3851 hearing was had, and the trial court granted, after having a hearing on both guilt and penalty, granted first relief on the penalty phase, but however, the guilt phase is now being appealed. I would like to start out by saying that the exact reason why I believe this case should be reversed, even though I understand that there is a lot of evidence linking Mr. King to a crime that happened at this scene, and that is that you have him with a lot of property that belonged to the victim, and you also have a piece of cantaloupe in the dining room of the house where this happened, where there was a match by, according to Hitt, who was the state's DNA expert, with very high frequency. So
can we just, because I know you're going to say then why our confidence should be undermined if we found deficiency, but on the DNA and the cantaloupe, the match isn't, this is one of the highest matches or whatever, the most, do you agree with that?
I agree that the profile is beyond, but yes.
Beyond, right? Okay.
No doubt.
They consulted with a DNA expert who said, you don't want me because I'm not really going to be able to put any holes in this, in the DNA. And then the expert at trial that was put on, that you put on, not a trial, at the evidentiary hearing, so it said, well, at one of the 7, there's some issue. So just if we just take the DNA and all of the property that was found, where is it that you go, our confidence is undermined by some deficiency of trial counsel?
This is exactly what I want to get to.
Okay, so let's hit it.
And I really do have to start from the beginning and to say this. This is a circumstantial evidence case as far as who did the killing in this case. This is a first-degree murder where you have death on the table in front of a jury, and who did this actual killing, this violent killing, is very important in this case. Very important. Who actually did it? In this case, so there is, as to who did the killing, that is circumstantial. There is no confession. There is nothing to actually link Mr. King as the actual killer. And bear with me for a second, because I think this is very important. In this case, the fact of that circumstantial evidence as to whether this is a felony murder, premeditation, a lesser, something else, was lost when the first detective was put on that stand by deficiencies by trial counsel. And the reason is this. The Detective Cayenne was put on the stand as the first major witness. He basically told this jury, who is not going to have any evidence that he's the killer, other than that he was there, possible, because we don't know when he was there, and I'll get to that. But the bottom line is, they said, we are very good detectives. We're honest men. This is what the detectives are saying on the video, and the jury's listening to. We are honest. You are a liar. I know you did the killing. I know you did the killing. I know the area that you're saying you got this property from, because I controlled it.
Didn't the defense attorney have an opportunity to sit down and redact all of those things that the attorney thought were problematic?
Yes, and that's my point. They did not. He did an absolute deficient performance in this redaction.
But here's the issue on that. He did redaction, and then he filed a motion in limine, and there were certain objections that he made to certain of the comments that you now say were improper. But number one, this is not a case where he's giving his opinion. Each of those are, this is what the legal issue would be. Each of those were elicited in response to try to get the confession from the defendant. And second of all, the ones that were objected to were not raised on direct appeal, and you haven't pursued a habeas case on ineffective assistance of appellate counsel.
There were no true objections in this case as to any of these. There were no objections. He said, the trial counsel said, I redacted certain things. I did find, and he called it a motion to suppress, but the bottom line is, they made an agreement between him and the state as to what should come in. In this case, this is akin to Sparkman and to Jackson. This is not a case because it's not soliciting a response as to who the killer is.
But if we disagree with you, that this wasn't a case of that these were just the opinions of the police officer, because I very much agree that as a matter of law, that's very dangerous. But we see that the comments that you've now pointed out were comments that were designed to elicit a response in context. Then don't you lose on that if on the law if we disagree with you on the law?
If you're correct.
So we first have, well, not, we're the,
obviously.
if we're correct, I'm saying if the law is such that in this situation, it is appropriate to say these kinds of things to elicit a response.
Right. I agree with you. And I apologize for the way I said that, but the bottom line is, Judge, I think when a person, it is very dangerous. It is very dangerous, and there must be great caution, I think. This, again, I think this is akin to the Jackson case, in which this court said, you know, you need to see if there's an actual response. And then if there is a response, I think then you do a 90.401 analysis.
Let me add one other question on this, because I know you have a short amount of time. When you said the first thing they did was put on the detective, is the testimony, did the detective give testimony at trial that was his opinion of guilt, or what you're objecting to, that you're saying the judge should have either sustained the objection or the defendant should have made additional objections, all from the interview?
Both, because he did make statements such as, when he's talking about Mumford and who gave the car to who, he said, I thought Mumford was forthright in his statement and he was honest.
Well, I thought issue one was that whether trial counsel was ineffective for failing to object to statements in King's interrogation video.
Right, and then...
Okay, so where is it? So the second one is failing to object to the trial testimony. So
right.
That's where you...
And based on either hearsay or that there wasn't a proper predicate, those kind of things. And we have a list of those. Okay,
but those are different, those to me were different objections than giving his opinion about the guilt.
I agree with you.
Okay.
Except that if a detective says that a witness who says that man gave me a video, that guy gave me a car, the detective says, when I talked to him, I thought he was being honest and forthright, that is an absolute and proper comment that should have been objected to. That's not right. And again, and
which record page is that? Well, you can do this on rebuttal. I don't want you.
It is, okay. And I can, and it's in the motion. It's listed specifically.
All right, we have every statement that you've either claimed as an issue. There are many of them you're asserting.
So if I could go back, I think this is akin to Jackson. And in fact, what the detective did is he used improper hearsay evidence and other improper evidence and basically painted a picture for this jury. He painted a picture for this jury, even if the trial court did an order saying, A lot of these statements are not harmful, and a lot of these statements don't really matter. But in fact, they do, because it allowed a detective to just get on the stand and give his own statement and take away from the jury any thought that this is circumstantial, any idea that there may be a problem with him being the killer, when in fact, there is no evidence that he was the killer.
Wait. Now, on that one, I'm having a tough
actual
time.
killer.
You say there's only circumstantial evidence. Well, yes, he did. I mean, he didn't confess. He first said he wasn't at the house, then he finally admitted he was in the house. He said she invited him in for cantaloupe, and the lawn supervisor said, no, that never happened. So he lied repeatedly until he said, no, he was inside the house. He admits that he had the property, and short of a confession, I'm not sure what the evidence, not that you have to prove he wasn't the killer, but whether, other than Montfort, and whether he, because his DNA was on the Cadillac, but he was ruled out. Did you point to Montfort as being the killer? Is there any evidence now in your post-conviction, newly discovered evidence of another killer, of something wrong with the DNA, anything of that nature?
No, not as to the DNA, but as to the whole idea that this is a case that needed to be argued, and can still be argued if given a chance, in saying that, look, there's more than one person involved in this case. The timing of this case, the timing of who was in the house, and whether this woman, the victim, was in the house at the time of the killing, or whether she was outside and came in, or who did the killing, is very important. Counsel, and this is outlined in my brief, counsel used unfair admission, unreliable evidence to prove certain things, such as there were 2 points of entry. They didn't bring 2 attempted points of entry that they didn't point out. 2. One was at the screen door, and one was at the garage door. There were 2 alleles on the socks that's not linked to the defendant, it's not linked to anybody else. So we don't know whose they are. The victim lived alone, and that's important. There is issues as to the cell phone and the location of the cell phone at the time of right before the crime, and whether he was at a bus stop or not. That testimony was totally unscientific. The detective, there's case law basically that says, detectives can testify somewhat to records, but they can't sit there and say it's going to hit the first cell tower. They can't say that it's going to that there's a direction. This tower faces this direction, because that's wrong. We put in an expert to say, look, the tower has antennas that you can't see. So the testimony by the detective is scientifically wrong. And this jury got the idea that this tower was facing the bus station where he was supposed to be, and it would be the first tower that would pick up his phone signal. And our expert basically said that's totally wrong. That's not how it works. That's not how the science is.
But they made a decision to cross-examine rather than put on their own expert. And there's some good, if you don't have, they had, in my view, I have some other issues, I'll ask the prosecutor about some of their trial tactics, but they had a reason for not putting on a cell phone expert, and they had a lawyer that was able, as far as I can see, and the trial judge saw, was able to effectively cross-examine the evidence on the cell phone tower.
I think that may be, but I think when you make decisions as to what expert you hire, that it has to be an informed decision and not just not hiring them. So the DNA expert, they talked to Budwali and basically didn't even give him the bench notes on this DNA. If they had done that, they would have found certain things, like in the case that were important, you could have preserved this cantaloupe by freezing it. There were 2 alleles that suggest that there may have been another person in the house on her socks. There are 2 points of entry. The shoes, the prints on the garage door, they claimed they put on Pfister, who is an evidence technician, who basically gave testimony that is incorrect. It is not scientifically accurate. She said these are large shoes, and the measurement was 11.61 inches, so that is a large shoe consistent with 12 or 13 that Mr. King has. Our expert said, no, you can't do it that way. That is not what the science is. And he found actually that it was 11.41, which is an 8 or 9 size shoe, which is much smaller than Mr. King.
But they didn't link the shoe prints, that the state didn't attempt to say the shoe prints were his.
That's my point is this. They absolutely did try to do that, and they argued that these are large shoe prints consistent with a man with large shoes. They absolutely did that. And basically, what I'm trying to say is that this was not correct scientific evidence. You have to, as defense attorneys, when you're talking about physical evidence, you have the ability to hire confidential experts to help you see if the science that the state is using is correct.
Would you help me? On the DNA, am I incorrect that the defendant admitted to his lawyer that yes, I committed this murder,
No.
and
Yes, go ahead,
may I
sir.
finish? Sure. And then the lawyer used that as part of the rationale to say, I do not want to further inculpate my client by going after more DNA information. That's not in this record?
What's in this record, what is in this record is that...
Yeah, this lawyer did not testify to that?
No, this lawyer testified, Eller testified, that there was...
Did he testify to that fact that I just mentioned?
Yes, and if I could just...
Okay.
If I could just...
Well, certainly, listen, but don't shake your head and say, no, it's not there, when it's here in the record.
I agree with you that it's there, but I think it's very important for this court to realize that was neither presented in. First of all, that doesn't affect how a lawyer should attack evidence and test the evidence. But second of all,
for DNA, are you telling me that if I'm sitting there representing a defendant and the defendant gives me information that would lead me to not go further on scientific information that may put the final nail in his coffin, that's inappropriate decision making by a trial lawyer?
No, sir. If that's what happened, it would be appropriate. However, that's not what happened. What happened was that there was a unsigned statement by a investigator with an alleged confession that was never signed by Mr. King, and that when we checked to see who went into the jail on the alleged state that this was written, that investigator had not gone into the jail, and secondly, that Mr. King had not been brought out of his cell for any reason. So, and both lawyers admitted that they never talked to Mr. King about that confession. And nobody...
Counsel, you have now exhausted about half of your rebuttal time. You only have 1 minute and 30 seconds left. If you want to continue, you may. And I will give you an extra minute, so you'll have 2.5 minutes.
Thank you.
May it please the court, my name is Jennifer Keegan, Assistant Attorney General representing the state in this matter. The claims before the court turn on whether or not trial counsel used strategic, reasonable decision-making in defending King's case, and whether or not those strategic decisions prejudiced his case. There's no question that the trial counsel in this case was extremely experienced. It was Quintil and Rafiq Eller of the Public Defender's Office in Jacksonville. Between the two of them, they had a combined experience of over 70 years of trial practice. These were highly, highly, highly qualified practitioners that were defending this case.
Can I ask a question about the bloody shoe print? The bloody shirt.
Yes.
What? It didn't become a feature of trial, but it's like, it's there, a bloody shirt in his house. I can understand some other strategic decisions, but to use that as sloppy police work to allow in all that evidence about this bloody shirt? What, could you just explain that as a matter of strategy?
Sure. So this was not a blood-soaked shirt, if you will. This shirt was discovered during a cross-examination, or during an interrogation of King. There was a search warrant that was being executed at his place, and the law enforcement officers were getting phone calls about the evidence that was being found. When they found this shirt, they did not know what it looked like, and they described it to him as, they aggrandized it and made it seem like it was a very bloody shirt. What is this shirt doing in your house? It has come out, certainly in post-conviction proceedings, that it was a significantly less bloody shirt. Unfortunately, there's not a photo of this shirt in the trial appellate record. It was an actual physical piece of evidence that was introduced. But there's testimony that it was 3 small stains. And, you know, it was a relatively small shirt. King was 6'5". This was a large men's shirt. And according to Mr. Till's description of it in closing argument, it would barely cover his chest. It was a very small shirt. It wouldn't have fit him. Now, during the interrogation, the law enforcement officers are repeatedly coming back to this shirt saying, be straight with us. What's going on with this shirt? How is this tied to the victim? And he finally caves in and says, okay, yeah, I guess it's my shirt. So Till used that.
Was the DNA, his DNA on the shirt?
Or
anybody's DNA?
There was DNA found on the shirt, but they were not able to match it to a profile, known profile. So they excluded it from the victim, and they excluded it from Mr. King. And the shirt was too small for him. So there's no question that this was not his shirt.
But it seems to me, again, there's 2 areas that bother me. That bothers me, and then the other thing that bothers me is that there were areas that it seems that with the confession or the colloquy that they made the decision not to object again, to preserve the objection for appeal if certain of the statements did not serve to elicit statements. But on this bloody shirt,
yes,
can you give me then, you think it's a reasonable strategic decision that they wanted to allow all of that in as opposed to seeking to exclude the interrogation part and exclude the bloody shirt from trial? I mean, wouldn't a trial judge have done that if a proper motion had been made?
Well, a motion was made, and
motion was made?
It was made. There was, in the motion in limine, to redact mention of various aspects of the interrogation video.
No, the bloody shirt. Was there a motion in limine on?
It included mention of the bloody shirt. That motion in limine, where they were trying to exclude portions of the interrogation video, included exclusion of the bloody shirt. Now, after some time passed, and presumably Till had more time to look at the evidence and evaluated his strategy as it was getting closer to trial, he and the state came to an agreement about what to exclude, and he chose not to exclude that. Now, he used that evidence to demonstrate that Mr. King's admissions during the interrogation video were suspect. So he got quite a lot of mileage out of the fact that King said, okay, yes, this is my shirt, when it very clearly was not his shirt. So he spent a lot of time on that in closing argument, that we can't really believe him saying that he was in the house. We can't really believe these other somewhat damaging things that he said in the interrogation video, because he said that this shirt was his when it isn't. So it was absolutely a reasonable strategic decision for trial counsel to do this, and it was presumably based on his 42 years of trial experience at that point. He recognized that this was a way that he could attack something that was damaging to his case. Because the overall theme of his case was that he was trying to say that there were problems with the science. There are holes that haven't been patched up. There are open questions that the state has not concluded. And he was, this admission from King saying that, well, okay, yeah, I was in her house and maybe she gave me fruit and things of that nature, sort of threw a wrench into his overall theme. So being able to attack that really, really helped him move the theory of his case forward. So it was absolutely strategic. That being said, there's no question that it wasn't prejudicial. The state did not rely on this shirt for any purpose. It was not mentioned in opening. It was not mentioned in closing. They introduced this shirt simply for the purpose of explaining that we found this in the process of doing this investigation, and it did not reveal any information or evidence that would tie into this case. And they did that with a number of pieces of evidence. For instance, when the fingerprint analysts and the DNA analysts were on the stand, they testified about things that didn't match anybody. They said, you know, we took this lift and it turned out to be of no value, or we swabbed these things and we weren't able to develop a DNA profile. So this just fit into the state's pattern of sort of trying to explain to the jury, we did take all these steps and we did our due diligence and we tied up all of the holes that we could, but this is one of those things that just didn't match into the evidence, it didn't tie into the evidence. And that was the extent of their use of it. It was absolutely not prejudicial in that regard.
On the motion in limine, I mean, first there was what the defense attorney testified to was like spending 100 hours
Yes.
on redactions and what they agreed on.
Yes.
So we have very thorough work by the attorney. But then subsequently, there was a motion in limine to seek to redact additional aspects of the interrogation. Is that correct?
There was a motion in limine to redact various portions of the interrogation video.
And that the judge did not, was that ruled on by the judge?
Not that I saw.
So is that not, if again, this is, wouldn't, if there were within the motion in limine on those points, other objectionable comments, and what was Mr. Till or Eller? Which one?
Mr. Till was the one who handled the interrogation video.
Okay,
Is
so
that the video the court is referring to? The interrogation video?
Yes, the
Okay.
motion in limine regarding the other parts that they thought should not have come in. What was their reason for not getting a ruling from the judge and then not objecting at the time that that part of the interrogation came in?
Well, counsel was being guided at the time, and I just want to clarify the law that existed at the time. Opposing counsel has mentioned the Jackson case. The state relied on a different Jackson case in its briefing. In 2009, the Florida Supreme Court issued a Jackson case, and the citation is 18 Southern 3rd 1016. That was issued in 2009. So when Mr. Till is testifying at the evidentiary hearing, he is talking about a Jackson case. That was the case that he was talking about. Jackson acted as a guiding hand, if you will, for his analysis of what was prejudicial, what was appropriate, what was not appropriate. And he determined that these statements that were left in the interrogation video were permissible under Jackson. Now remember, Jackson essentially stands for the concept of if you are able to elicit a responsive answer from the defendant, then the law enforcement officer's statement is allowed in for the purpose of establishing
Sure,
context.
I understand that, but that doesn't, are you saying that Jackson came out between the time of the motion in limine and the time of trial?
No.
Okay, because he objected, I'm assuming in the motion in limine, that alibi is shot, I know you did it. I mean, that's just one part of it. Well, all I'm asking is,
That portion was not in his motion in limine. That statement, the
was
alibi
it
is shot, I know
objected-
you did it, that was not part of
It
his.
wasn't objected to?
It was not.
Okay, so are there portions, all I'm asking you is why, if he filed the motion in limine, didn't he get a ruling on it to allow that to be an issue on appeal?
Because he did his due diligence, he more than likely, it's not on the record at the evidentiary hearing, but we can presume that he practiced in a methodology that's similar for very practiced trial lawyers, and he asked for more than he thought he could probably get in his motion in limine. That's a common practice. So you ask for more than you expect you can get, and then that puts you in a position to negotiate. And so he sat down with the state attorney following filing that motion in limine, and he negotiated with the state attorney, and he testified that he redacted all portions that he thought were impermissible. Everything that he left in involved a response from the defendant or provided context for something that the defendant said that was valuable evidence in trial. So for instance, the statement that the court just mentioned, that alibi is shot, I know you did it, Mr. King then steps into a explanation about how this is really his cousin's fault, his cousin must be involved in this, he's heard these guys talking and the like. So this was part of the state's establishment that Mr. King's explanations for all of these incredibly incriminating pieces of evidence were incredible, if you will. And this was certainly part of that demonstration. So for defense counsel to have redacted that, first of all, the state never would have agreed because it wasn't necessary under Jackson. Second of all, if they had redacted that, the following explanation that Mr. King gave would have made no sense. There would have been no context because we wouldn't have been able to see what it was that he was responding to. Not only that, but this court has also explained in McWaters, for example, that juries are presumed to understand that the statements that are made in interrogation are made for the purpose of eliciting a confession from the defendant. They are tactics. They are not statements of opinion that are meant to be taken for the truth. They are not statements of bias. They are not statements of bolstering witnesses or the like that are intended to be taken for truth. They are seen as strategic methods, if you will, and it is expected that the jury is going to understand that. Now, I believe opposing counsel did mention very quickly regarding DNA, shoe print evidence, and the like. Mr. Eller and Mr. Till both testified about the fact that their decisions about what experts to call, what experts to consult with, was informed by Mr. King's confession to their defense team investigator. He confessed that he committed the murder and that he was the sole actor in the murder. Those things are obviously very important considerations when you're deciding whether or not to go through the victim's house and test evidence and potentially create evidence against your client. Now, as opposing counsel mentioned, they certainly could have gotten a confidential consultation, and they did do that. They got a consultation, a confidential consultation with a DNA expert, but they could not go through testing these items of evidence confidentially. There's no question they would have needed a motion, and it would have sent up a flare to the state attorney's office that they were testing these items. Then if they are not going to be producing any expert report and they're not going to be presenting any expert evidence, the state now knows that that's potentially evidence against the client that they could go look at. That was exactly what Eller and Till were trying to avoid doing, and they made a decision not to go down that road, not to retest things, because they didn't want to create additional evidence against their client. Now, I believe that concludes all of the points I wanted to address. If the court has nothing further for me, I just ask that the court affirm the ruling
I do have
below.
one question.
Oh,
There
of
was
course.
there was an interim motion that came to this court that was the, about additional testing that they wanted.
DNA testing.
That isn't, but it never happened and it hasn't been pursued, correct? So or did it?
There was DNA testing. So they asked for several different items to be tested. They asked for the shirt to be retested, the shirt with 3 blood stains on it. They asked for that DNA testing to be redone. They asked for some fibers off of that shirt to be retested, or to be tested because it had never been tested. They asked for the fingernail clippings from the victim, which returned no DNA evidence, to be tested. And they requested a shotgun and some shotgun shells that were found in the defendant's home when his search warrant was being executed. They requested those things to be tested. Now, the trial court denied all of those requests except for the fingernails. She conceded that you can have the fingernails retested. They were retested, and the results matched what the state expert demonstrated. Now, obviously, there was an appeal on that. The court determined that that was, in effect, an interlocutory appeal, and applied the appropriate prejudice standard and determined that there was no emergency miscarriage of justice that would happen if they ruled on the issue and it was sent back. So yes, the fact that that has not been raised now demonstrates that it's been abandoned.
That's what, I just want to make sure about that. So there was no
It was
further
abandoned,
testing.
yes.
Okay.
Yes, Your Honor. And if there's nothing further, I just ask the court to affirm the trial court's ruling below. Thank you.
Just briefly, Justice Periente, the redactions. There was a motion filed. That motion was not followed through on. These are incredible, these statements, after the jury hears it, their only thought is that Mr. King is a killer. He's a ruthless killer, and the detectives know who did it. This isn't an issue like McWaters. This is an issue like the Michael Jackson case and Sparkman, and that was very clear that that was the law at the time. And by the way, this is exactly what happened in the Michael Jackson case, which this court reversed on a redaction issue. Exactly the same issue. That there was a motion filed by another lawyer objecting to all of these things. They basically abandoned it by negotiating and letting all these statements in. And these are the same lawyers involved. It's the same issue. And it was incredibly prejudicial. And I understand that defense counsels have to be careful about what they test and what they don't test. But the bottom line is, you can have confidential testing with no reports. And at the time, Kidder wasn't even in effect at that point. So, and they didn't even try to get an expert on any of these. Had they gotten an expert, they could have and this is all in my brief, they could have gotten evidence that more than one person is involved. If you got more than one person involved and you can argue that you don't know who the killer is, then you have issues in this case which are important and why this should be retried as to whether it's first degree premeditated. Juries don't like felony murder, if that's what you rely on, if they don't think the person's the killer. There's a chance that they could have gotten, a reasonable chance that they could have gotten a different verdict. Perhaps not guilty, but a lesser, something else. And it certainly would have affected whether they believed that this person should get life or death. And none of that was done. They also...
Counsel, your
Yes.
time has now expired.
Thank you, I appreciate it.
We thank you both for your arguments.